Greetings, this is Chapter 4, Legal Construction of the Employment Environment. What we're going to do in this chapter is start reviewing the different HR activities that go on when you are engaged in an employment relationship. And this includes things like recruitment and performance appraisal and discipline and things like that. And how does employment law apply to these issues so that we are aware when we go about our daily business as a manager or as an employee or as an HR professional to figure out how we make sure that we are complying with the laws. There are 7 learning objectives in this chapter. The first one, explain why employers should be concerned about ensuring protections for equal opportunity during recruitment in particular. And as you know, recruitment is the first step in the process of bringing someone into the organization and building an employer-employee relationship with them. And so we have to be sure that we are setting the tone properly, doing things legally and appropriately in the recruitment process, because that becomes a signal for what people can expect once they join the organization. We have liability issues that we need to be aware of, that we're not discriminating and things of that nature. Number 2, describe how the recruitment environment is regulated by both statutes and common law. And we'll get into more detail on the laws, which laws apply to the recruitment environment, and specifically the common law aspects of managing recruiting. Number 3, describe the employer's opportunities during the information gathering process to learn as much as possible about hiring the most effective worker. So where should we be thinking about what information we're gathering and what are the best ways to gather that information, and how does that relate to the equal employment law issues to make sure we're not discriminating but yet making sure we're hiring the best possible workers. Number 4, explain how the employer might be liable under the theory of negligent hiring. We have a due diligence that we need to engage in to make sure that we are not hiring inappropriate people who may put us at risk, whether they are, if they've committed crimes and have not been held accountable for those crimes, if we're doing background checks on them, all those sorts of things. So it is important that we make sure that we are engaging in appropriate protection of our employees and and not engaging in any kind of behavior that would make us liable for having somebody harmed by our hiring decisions. Learning objective 5, identify the circumstances under which an employer may be responsible for an employee's compelled self-publication, thus liable for defamation. And we'll get into what that means. It's a lot of legal concepts, which it's important that you understand those. So we don't want to compel someone to engage in disclosure about something about themselves they don't want to. Number 6, explain the difference between testing for eligibility and testing for ineligibility and providing examples of each. And again, if someone's eligible for a job or ineligible for a job, there's 2 different kinds of assessments that we can do around that. Identify the key benefits of performance appraisal structures as well as their areas of potential pitfalls. And so performance appraisals are also covered under equal employment law and EEO law, and it's important that we make sure we understand the different ways that we can do performance appraisals and why some of them are better than others from a legal perspective. So the employment relationship evolves from the recruiting phase, the sourcing and recruiting phase, through either the point where they separate from the organization, whether it's because of retirement or they quit for their own reasons or they're fired or laid off for whatever reason. And so our employment relationships start in the sourcing and recruiting phase, which is how we attract qualified applicants to our organization. And recruitment is incredibly important because the better job we do at recruitment, the easier it is for us to hire people. We have to test people to make sure that there's assessments that are done that are related to the type of people we want to recruit that are going to be best for the job. And so if we want to hire someone, we want to make sure that we're assessing them appropriately to be able to do that job. And the criteria we use in recruiting, as well as the criteria that we use when we're assessing them, need to be related to job-related characteristics. Performance appraisals also, right? If we are hiring someone and we set the tone for what kind of behavior we expect and what performance levels we expect, performance appraisal or performance evaluation, it has to be linked back to what we communicate to people during the recruitment process, so they are aware of what we expect, what level of performance we expect, what's going to happen if they don't. And the same thing with discipline, right? If someone doesn't do that, then discipline is how we manage performance. And performance appraisal is usually about how we evaluate performance. Discipline is about how we evaluate people's behaviors with respect to company policies and rules and regulations. And so someone gets disciplined, not because they're a poor performer, but they get disciplined because they have violated a company policy. And so I'm sure you can be aware, EEO law has a huge impact on disciplinary procedures, because if the organization doesn't hold their people accountable for poor behaviors, then they are putting themselves at risk legally to be sued under EEO law and various other laws, certainly as appropriate. So you should be aware of that recruitment helps us to do better hiring. It sets the tone for testing, and it also helps us to be clear about what are we going to evaluate people for performance. Excuse me. How we're going to evaluate them for performance, as well as how we're going to manage their behaviors in terms of setting expectations for certain behaviors with respect to company policies. So recruitment, as I stated earlier, is the first step in developing the employment relationship. We usually start with sourcing which resources we're going to use to attract qualified people, and then we need to assess the individuals as they apply and determine whether or not they're going to be able to stay in the hiring process, or whether we remove them from consideration from hiring. And, how do we get somebody from potential applicant to job candidate, somebody who we believe is going to make our short list and somebody who we want to have and we want to hire? It's important that we set that up. So it is important that we recognize that the better job we do at recruiting, the easier it is for us downstream, as I said in the previous slide, right? It's better hiring. We will have a better output from our assessment or our testing process. We're going to have better performers, and we'll see that with performance appraisals, and we may have less issues with discipline. So we have to do a good job in recruiting to make those aspects of our jobs much easier. There are 4 basic statutes that you need to be aware of. Number 1 is Title VII of the Civil Rights Act. And again, we are held to the same standards in the recruitment process as we are at the hiring decision, or while people are in the organization working for us. We don't discriminate based on protected categories, as we've talked about. And we have to make sure when we're making decisions that we are considering equal employment, and we're making sure that we're not differentiating inappropriately in the decisions that we make during the recruitment process, and let alone in making the final hiring decision. In the recruitment process, there's a lot of danger that we would be making discriminatory decisions as we screen people out. The Age Discrimination in Employment Act of 1967, same thing. If we're going to recruit people, we cannot treat people who are over 40 differently than we treat people who are under 40, and we should consider them for employment just as much as we would any other candidate for the job. If they have the experience and the skill set, and regardless of their age, they should be considered for employment. So we need to make sure we're also recruiting from and not discriminating in our recruiting process attracting qualified people of any age to our organization. And as we get into that chapter, I believe it's chapter 12, talking about age discrimination, I think it's important for us to recognize that there are sometimes employers that use targeted recruiting messages that actually are discriminatory against older workers. So we want to be careful of that. Immigration Reform and Control Act of 1986, we want to make sure that we are attracting qualified, able to work in the United States workers, and we need to make sure that we are using criteria that is appropriate for attracting. Now, if you're willing to pay for visas for somebody to come work in the United States with a visa, then that's okay, and that's part of your recruitment process. That should be the message that you communicate to people in the recruiting process. But you are obligated in the recruiting process to make sure that you hire people that are eligible to work in the United States. And so you would use an I-9 form, and that I-9 form is a self-report on the part of the employee or the applicant that they verify that they were qualified to work in the United States. They have to provide information verifying that as such. And then lastly, the Vocational Rehab Act of 73 and the ADA of 1990. Both of those laws together are dealing with how do we hire people who may have a disability and what are our obligations under that. And it is important that we recognize if someone has had a series of workers' comp claims because they were injured on the job, we can't discriminate against them. In fact, we can't even ask about workers' comp claims during the recruitment process. And as well, during the recruitment and hiring process, we can't ask people, do they have a disability? We simply can ask, can you do this job with or without a reasonable accommodation? And people just answer, yes, I can do the job, or no, I can't. And then we can kind of move on from there. So it is important that we are clear legally about how disability impacts our ability to recruit and what we can and can't ask in that process. Along with federal statutes and protections, as you see in Title VII, many state employment laws also mirror or expand on those statutes. So, for example, there are some states that say we can't use age as a decision factor during the hiring process. And even though the federal government says it's only protecting workers 40 or older, there are some states that actually protect people of any age from using age as a hiring screening tool. In terms of other issues to be aware of, there are some common law recruitment violations. For example, fraud. Are you purposefully, intentionally misleading somebody? And if you go to your textbook on page 159, you'll see the more detailed definitions of what fraud, misrepresentation, and material facts mean. Fraud means you're misrepresenting a material fact with the intent to deceive, and it's done with recklessness because you are verifiably trying to hide the truth from somebody. Misrepresentation means you're making a false statement that or it's a true statement that's misrepresenting a particular impression. You can say a truthful statement, but there may be other contextual issues that you're not being aware of. And then lastly, this idea of material fact. It's a statement of fact. It's not an opinion. There are material facts involved. And if you are not sharing appropriate facts, that is a concern. So material facts are relevant, particularly when we enter into an employment contract. We want to be sure that we are representing facts and not opinions when we're addressing contractual issues. So regulations apply to all different kinds of recruitment practices. For example, the kinds of advertisements that we want to give. We want to be sure that we are not misrepresenting or committing fraud with respect to what we're advertising for people. So we don't want to tell them in advertising that we are writing requirements that may be discriminatory. So looking for a young person with lots of fresh energy to come and do this job, well, that discriminates against people who are older. So we want to be very careful as we are writing up our ads that we are not necessarily discriminating based on age, race, religion, color, you name it. Now, some advertisements can restrict with respect to religion when they are directly related to religious activities, right? But, somebody who's basically working as a secretary in your church doesn't necessarily have to practice those faith traditions. They simply need to know how to be a good secretary. So you can probably not necessarily require somebody to be a particular religion in order to be able to do secretarial work. So that's just one example there. The other issues that we should think about with respect to recruitment practices is word of mouth recruiting. Word of mouth recruiting means that you ask your employees or yourself or people and you ask people that you know to come and work for the company. So word of mouth goes out and it spreads. And the challenge with word of mouth is that we can't control the pool of applicants that we are trying to reach and to attract to come and apply for our company. And so if I'm a company that's trying to be more diverse and I have mostly white people, if I only use word of mouth recruiting, and I mean only use it, we're going to create a problem because we're only going to attract people who look like us and act like us. That's common sense and that's common nature, human nature, the way that humans behave. Without thinking about it when it's mindlessness. But what we're looking for with word of mouth recruiting is to use it as one tool, but in combination with other recruiting tools that don't have an adverse impact or purposefully may discriminate against pools of people. So we might use word of mouth, but we have to use it in conjunction with other tools. Particularly if we are looking to make more diverse hires. This is really important to know because otherwise we're just going to attract people who look like us. And then I'm going to miss a whole group of people that could have been well qualified for the job, but I just didn't reach out to them. Other issues, promoting from within. And when we promote from within, that is a good reward for people. We know this, right? That if you dangle the carrot of a potential promotion to somebody, they would like that and they would like to stay with the company. And there's the incentive to stay with the company for the long haul with the potential that they could be promoted and grow within the organization. But what we know from past history, right? When an organization only promotes from within and doesn't hire people from the outside, number one, you have a very homogeneous workforce where people tend to not question the status quo. They tend to just comply. Everybody starts to think alike and act alike and behave in very similar ways, which can have some discriminatory effects in the company and also can create some competitive issues, right? Homogeneous companies cannot compete in the same way that a heterogeneous or diverse companies can, simply because they become very locked into one way of being and one way of thinking, and they're not willing to challenge each other. So from promoting from within also runs into the same problem as word of mouth recruiting. If you are promoting from within and you have a non-diverse company, all you're doing is reinforcing the lack of diversity. So we do want a balance with promoting from within and external hiring and recruiting when we want to keep our company fresh and able to be adaptable and more diverse, right? Venue recruiting. We can recruit in some venues. For example, you go to a high school or you go to a college to recruit people from a particular school. But let's say when you're recruiting, you only go to the white high school in your neighborhood, but you don't go to the black high school down the road. You only hire from New York University, you don't hire from Howard University. So when you are doing your venue recruiting, we want to make sure we're using diverse schools that have a wide variety of applicants from different backgrounds so that we can increase the likelihood of recruiting the best possible candidate who also happens to be diverse, right? Walk-in applicants. Again, walk-in applicants, we can't control the quality of walk-in applicants. While they might be good, there's no guarantee they are. If that's the only source we're using, that's going to be problematic for us. So we want to use walk-in recruits or walk-in applicants along with a host of other sources where we're purposefully going out and actively recruiting people who are different, a wide variety of sources where there's different information, different ideas, different education, different perspectives, because we don't want homogeneous organizations. We want heterogeneous, diverse organizations in that context. Neutral solicitation. So basically, while we're selecting an appropriate source, it is important that we encourage those diverse applicants. And so we want to be careful about even the terminology that we use. If you need to have a busboy, why would you say busboy when you could say someone who knows how to bus tables? Right? Because busboy assumes that only men can do that job. Or saying we want recent college grads, but in fact, you'll take anybody as long as they have the characteristics that they need to do the job. And so you would be discouraging older workers from applying for that. So your solicitation needs to have neutral terminology in it, meaning that we're not going to say, well, we only want, recent college grads, because then also that discourages any older workers, or it may be that the college grad is not necessarily a requirement for the job, and so you would also be using terminology that it may seem on its face value that it's not discriminating, but in fact it is. Saying a salesman or a saleswoman, how about a salesperson? Use that neutral terminology. The note at the bottom, we're going to talk more about this when we get to chapter 14, but the use of artificial intelligence as a screening aid for screening applicants doesn't insulate us from discrimination. And in fact, it may increase it, so we have to be particularly mindful about the impact of technology on issues of privacy and discrimination for the purpose of for hiring and recruiting and things like that. So we'll talk more about that as we get later on into the material, towards the end of the class. But it is important for you to recognize that artificial intelligence, any kind of technology, doesn't insulate us or protect us from being accused of discrimination.